Hello, whoever's watching. Welcome to this webinar, which is a legal bootcamp. Let's talk about what this bootcamp will be about. This is a quick summary of the basics any business person needs to start their business from the point of view of a business attorney. I'm not a tax specialist or a CPA, so I'm not going to tell you how you're going to save the most money on tax. But what I will tell you is how to set up your business and the issues you need to be aware of to protect your assets and to make sure that your business is running properly. How to choose the right business entity, how to form the right business entity, and what that means. So let's begin. The first thing I want to say is don't be a victim of paralysis by analysis. Don't delay in starting your business. Even if you're not sure what the right choice of an entity is, just get decent insurance and a business license. Regardless of what you may have seen on the internet or heard from less scrupulous advice givers, when your business is small, your risk is small. If you get the wrong business entity, if you get something wrong in your bylaws, your contracts are small, your liability, your exposure is small. As long as you make sure you have insurance, let's say you open a restaurant, you have insurance in case somebody chokes. Right? That's pretty apparent. Everybody should have that. But as far as the details of the setup, when you're just starting up, the risk is small. It's more important to get off the ground. It's more important to get going. Don't delay on getting things right, but don't focus on that to a point where it becomes a matter of paralysis. So there's other important requirements to starting a business besides just forming your entity. The first one is you need a local business license or a tax certificate to operate locally. It's wherever your business is. You contact Sacramento City, Sacramento County. If you're not in the city area, Elk Grove, sometimes they call it certificate, so that's what you need. You also are going to need to go to the IRS website and get an employee identification number. Now, if you are a solo, which we'll talk about later, which means you have no entity, you will use your social security number. But if you have other employees, even as a solo, which I don't recommend, or if you form an LLC or any other entity, you will need an IRS identification number. You just go to the IRS website. It's a 5-minute form. It's very easy. You get your number. You're going to need to get licenses and permits. Different businesses need different licenses and permits. In the slide, you will see a website, calgold.ca.gov. It's a very helpful state website. You go there, you describe your business. They're going to tell you what licenses and permits you need. And there's hundreds of these. It depends. Are you a plumber? Are you a store? Are you a restaurant? They're just going to tell you what you need. Very important. You may need a fictitious business name. Now, some words about fictitious business name. Sometimes they're called DBA. DBA means the same thing. It's doing business name. Doing business as. It means the same thing as a fictitious business name. What these are any names you use that is not your business name. So for example, if your name is John Smith and you want to open a coffee shop called John Smith, you don't need a fictitious business name if you are a solo. If you are a corporation and you open a corporation and your corporation is called Coffee Company, not John Smith Coffee Company, but Coffee Company, and you open up a coffee shop and you want to call it John Smith, you're going to need a fictitious business name for John Smith. So whatever your company name is, that's a real name. You don't need to register it as a fictitious business name. Whatever your name is, it's a real name. But if you have any enterprise that's under any other name, you will need to register a fictitious business name. On the slide there, I have some instructions. Essentially, the county where you operate, usually people just do it in Sacramento County if they're anywhere in this area because they have the easiest process. You have to file it with the county and then you have to publish it in a proper newspaper. If you go to a website called dbastore.com for like $60, they're going to do the whole thing for you. It's very cheap. Otherwise, you can save $30 and maybe do it by yourself, but then you have to find the right newspaper. There's other service providers, but there it is. Continuing with other important requirements, you need insurance. As you notice, I put a separate slide aside for insurance because it is that important. Because at the end of the day, if you remember our conversation from just a couple of slides back, don't be a victim of paralysis by analysis. Just get insurance and get going. Your ultimate liability protection is insurance. There are many different types of insurance. I have listed here general liability, premises liability, professional liability, malpractice, errors and omissions, directors and officers, and umbrella policy. You should know what these mean. Premises liability is pretty obvious, right? Somebody slips and falls. You only need that if you have a premises. If you're a virtual business, you don't have premises liability. Professional liability, malpractice insurance, errors and omissions, they're all terms for essentially the same thing. That's if you do something wrong in that area in which you were hired for, your job, the thing that they're hiring for. So you definitely need that. Directors and officers, you don't usually need that. If you're a corporation, you might want to get special insurance for your directors and officers. And an umbrella policy is a policy that covers you against catastrophic loss. Again, it's not necessary most of the time, but you might want to consider it. So for example, you have premises liability up to $3 million. But then, a whole, a truck full of people passes away in your premises in one day. Your liability insurance isn't going to cover it. And that's where the umbrella policy comes in. Umbrella policies are particularly important for maybe restaurants that serve seafood, because you could really have catastrophic loss there, and things like that. So always make sure to have insurance. That's your best line of protection for your assets, and it's required anyway. To get insurance, now most people don't know this, to get insurance, don't buy insurance directly, go through brokers. Just Google commercial insurance brokers. You'll find a bunch in your area. Get quotes from multiple brokers. It's hard. Most business, especially these days when you have a lot of online small businesses doing different things, they're not really standardized, and different brokers will understand it differently, and you might get vastly different quotes, not just depending on what the ultimate company that's insuring you is, but on the broker and how they understood what your requirements are. And this is why it's important to get in touch with a few brokers and get a few quotes through each broker. Particularly key here is, as long as we're talking about how to ultimately lower your liability, brokers carry malpractice insurance or errors and omissions insurance for their words. When you do narrow it down to a broker, to a couple of quotes, you want to make sure to ask that broker in writing, email, questions about whether or not you're covered for this, that, and the other thing, and make sure that you get answers in email. Because if they're not answering you in email and just giving you a call, you know that they're shady and they can't be trusted. You need those answers in writing. Why do you need them in writing? Because if your broker tells you you're covered for something, you're covered. Even if the ultimate insurance policy doesn't cover you, the broker's errors and omissions insurance policy will cover you. Something very important to keep in mind. Use your broker, use their insurance policy. So the next slide here is something very typical. On the right, you're going to see a summary of benefits for a choice of entity. And if you squint really hard, you should be able to read it, but maybe not. There's a lot. You'll find these types of charts across the internet when asking people, what's between an LLC, an SCorp, or SCorp, and people look at these charts. They'll have these various things about, SCorp has maximum 100 shareholders, SCorp has unlimited shareholders. People try to look at these charts, try to figure out what they are. Just forget about them. They are really a marketing tool. They're a good general summary for attorneys, but they're mostly a scare tactic. The fact is, for most things, anything in that list is a default, and you can override most things in the law. So like there's this code for how LLCs, for how corporations are made, but the corporation, the LLC, the partnership, they can create contracts that override all of those defaults. And so these charts are next to useless. There's a few basic things that you should be aware of, but most of the information in this chart is useless. The kind of things that I'll probably repeat over the course of this presentation is basically, if you're looking for venture capital, you basically have to be a C corporation because venture capitalists only invest in C corporations. Lots of people invest in LLCs and SCorps and solos, and there's plenty of good contracts, but the kind of Bay Area venture capital stuff, they only look at C corps. I think that's really the main thing you have to be aware of. Other than that, most things are malleable. So from what it says on the left here is, from a legal viewpoint, each entity provides adequate protection if done properly. And the differences from these are just the base code, and any attorney can sort of make an LLC work for you or make a corporation work for you. It's just a matter of it being a little bit more work. Now, how do you choose then? Well, again, making an LLC work for you with your particular situation might just be too much work and too expensive in contract terms, and it might be easier to turn to a corporation. Something only an attorney can tell you. But the other way you do this is you go to a CPA, you pay for a proper CPA consultation, you figure out which one of these will provide you with greater tax benefits, and then you just tell the attorney to make that one. CPA is much better at helping you choose because they understand tax, but only an attorney can properly form that entity. So here are the basic entities, and this is probably what you want. If you've heard about the existence of other entities, don't worry about them. There's a lot of other stuff out there, but you have to know why you want it. You have to already be aware of these benefit corporations, social purpose corporations. There's a lot of options. If you are advanced, if you're comfortable with your corporation and you know a lot about, then you talk about it with your attorney. But right now, really these 1, 2, 3, 4 options, 5 options really are all you need to be concerned with. And those are sole proprietorship, general partnership, limited liability company or LLC, C corporation, and S corporation. Everything else is non-standard and does not do for beginners. All right. It's important to understand that sole proprietorship and general partnership have personal liability. So this means that you're personally liable for the debts of the company. LLCs and corporations do not have personal liability, which means that the company is the only one that's liable. This comes with a lot of caveats, which I'll harp on repetitively probably. The first one is, if you have an LLC or a corporation and you don't have insurance, you're what they call not properly capitalized. And again, you're personally liable. So you have to have insurance. You can't avoid paying for insurance. You might not have to have as much, but ultimately you still have to have insurance. The other thing to be aware of is with a sole proprietorship, right? You're liable for whatever the company does. But with a general partnership, you're liable with whatever your partner does. General partnerships, unless the partnership is between two limited liability entities, so for example, a partnership between two corporations, that's okay. General partnerships between people, I would strongly advise against that, because if you are a partner of somebody, you're liable for everything that they may do. And there's something called a parent partnership and a parent authority, which extends beyond the life of the partnership. So for example, let's say Terry and Sam form a partnership. Terry and Sam are in the business of remodeling. They remodel homes. Everybody knows they're in a relatively small town. Maybe they're in Rockland. They remodel a lot of homes. People are aware of the fact. They have posters everywhere. After some time passes, Terry and Sam split up and they're no longer partners. Some more time passes, Terry becomes an alcoholic. While carrying some products in their truck, Terry veers off to the side, smashes into a restaurant, runs over a bunch of people. Sam is going to get personally sued now. because Terry had items in his truck. People thought that Terry's Sam's partner, and they had reason to do so. The fact that he wasn't Sam's partner at the time is not relevant. All that's relevant is that people have reason to believe that he was. And now Sam is suddenly personally liable for all of that. And this is why you want to avoid general partnerships. Congress understood all of that. I'm talking about the state Congress of most states. And that's why LLCs were created. LLCs are literally partnerships that have been taken and reformed to have limited liability. With that being said, so on the limited liability side, we have LLCs, which are reformed partnerships, and we have corporations. C corporations are good for big business, and then literally Congress, this time the federal Congress, took a look at how to make corporations more friendly to small business, and they formed S corporations. So again, for small businesses, the best limited liability entities are LLCs and S corporations. Don't worry too much about which is which. So that's that. Now let's talk a little bit about state versus federal when it comes to the entities you can have. So on the left, you will see all of the entities available at the federal level. There's sole proprietorship, partnership, don't be a partner. C corporations, S corporations, something called a cooperative, which is very complicated and way beyond the scope of this class. Notice there are no LLCs at the federal level. The federal government has not passed an LLC Act, and there are no LLCs. But they're so popular, they're in every single state, that the IRS does have a website dedicated to LLCs. And essentially, when you have an LLC, you and your tax professional will choose how you're taxed. You can be taxed as a solo, as a partnership, as a corporation, C or S. So at the federal level, LLCs are taxed as something else. It's only at the state level that they're taxed as LLCs. Now, the state level is where you form your entity, right? The majority of your tax you pay at the federal level with the IRS. There are state taxes, but they're comparatively small. But you file all of the paperwork at the state level. At the state level, you have many more choices. I don't think... So I did not include a slide because this is a shortened form of the presentation for how many entities, but there's easily over a dozen. Social purpose, flexible purpose, public benefit. There's just a lot of different entities you can form. Again, don't worry about them. Generally, just stick to solo, LLC, or SCorp. Now, a word about S corporations. There's really only one kind of corporation. So at the state level, you file for a corporation. And every corporation, by default, is a C corporation. If you meet the requirements, which if we have enough time, we'll get to later, but basically less than 100 shareholders, only one class of shares, nobody's a foreigner. If you meet the requirements, you can ask for special tax treatment, which basically you don't pay corporate tax anymore, and the IRS will grant you the status of being an S corporation. It's basically just a special form of tax treatment, and so since it's formed the same way, you can always switch between S corporations and C corporations with great ease. It's just a matter of filing a piece of paper with the IRS. You can't do it very often. You can only do it once every 3 years, but it's easy. There's a special thing that I wanted to discuss called California Close Corporations. It is a special state status that allows your corporation, allows you to have basically a corporation that relieves you of a lot of the corporate formalities. It's very good for family-run businesses who want to enjoy the benefits of a corporation, which oftentimes, for a large company especially, there are substantial tax benefits with being a C corporation because you can have employees. Again, they're good for larger businesses. So it's a family-owned larger business, like healthcare benefits, retirement benefits. You want to have this flexibility, and this is where close corporations come in. Now, there's a bunch of requirements. You have to have maximum 35 shareholders. The term Inc. or corporation must be in the name. There has to be a special shareholder agreement. But essentially, it allows you to relax all the formalities, run it like your own family business without worrying about losing protection. These things were really popular, and if you talk to a lot of like older attorneys, they used to form them all the time. They're still good, but essentially they seem to have fallen out of fashion. And the main reason is because LLCs exist now. And LLCs, I think they came around like in the late 70s or something like that, but they're just an easier way of accomplishing the same thing. And one of the added benefits is with a corporation, it's easy to, you can't ban people in a corporation from selling their shares to somebody else. You can put a lot of obstacles, but ultimately shares are personal property. So as many obstacles as you can put, there's still risk that you're exposed to. Whereas an LLC, since it's formed like a partnership, LLC members cannot sell their thing to somebody else without the approval of the other LLC members. And for family businesses, that's actually pretty attractive. You know, you can't have somebody who sells outside of the family without the family's approval. So now let's go over some of these entities. Let's talk about what a sole proprietor is. Sole proprietor is basically just you running your business. I am a sole proprietor. I'm an attorney. I have excellent malpractice insurance. Don't really need anybody else. So I have not, I just go around, I pick up clients, I do the work, I have an office. That's it. One of the key elements to being a sole proprietor is you're alone. Because if there's more than one of you, you're a partnership. All right? You're personally liable for everything. But again, what could I possibly be liable for outside of malpractice? And I have insurance for that. I have an office, but I sublet, and so somebody else carries the insurance policy on that. And that's really it. You may need a DBA, but I use my name. If you go beyond using your name, you will need a DBA or a fictitious business name, as we discussed. Now, there is no entity, right? There's no fictitious entity. There's just you. You don't get a salary, but you just draw the profits, and you're subject to self-employment tax. You are the company, so profits are taxable the year they're made. One of the disadvantages of solo proprietorships, and this is the same disadvantage for LLCs and S corporations, is it's very difficult to let money accumulate. All of these entities pay taxes the year that the money is made, and they pay the full brunt of the tax, which can be as high as 50% when you combine the state tax. We'll talk about this later, but if you are a C corporation, which pays corporate tax is comparatively small, it's like 20%, and the rest of the money can sit there and accumulate. Right? So it's something to be aware of if you want a company that can build up its assets easier. That is definitely a C Corp. Now let's talk about a partnership. Don't do it. That's my biggest piece of advice with a partnership. Don't do it. It's a horrible idea unless you're both limited liability entities, in which case it seems like it's really too complicated. You could just be shareholders or LLC members in one entity instead of having two entities that then form a partnership. Seems unnecessarily complicated. But, each partner in a partnership can bind the whole. Each one can speak for the partner. And this is important to understand. It doesn't matter what agreements the partners have amongst each other. As to the third party, if, getting back to the example of Terry and Sam, if Sam, early on, the reason they split up was because Sam found out that Terry was an alcoholic. And 3 years before they split up, Sam told Terry, don't sign any contracts, you're not allowed to do any of that. They signed a piece of paper that said Terry's not allowed to sign any contracts. But they continue in the partnership. Terry goes out and signs a bunch of contracts. Guess what? Sam was responsible for all of those. Sam can go out and sue Terry and try to get some of that money back, but good luck. You're responsible to the third party for everything. Each of you is a fiduciary of the other, which means each of you is responsible for treating the other partner's assets as their own. You can't compete with a partnership. You need to have a very solid agreement, and tax-wise, you pay for your share as a solo. Okay, just, the most important thing to take away from here is try not to find yourself in a situation where you're in a partnership, general partnership. All right, let's talk about limited partnerships. So this is a special type of partnership. It's generally used as an investment tool. And the way it works is that there are general partners and limited partners. General partners are people who run the business, and limited partners are investors who don't run the business, they just invest. Now, a limited partnership is something you have to register with the state, unlike a general partnership or a solo. A limited partnership needs registration. But in a limited partnership, the limited partners, who are just investors who don't work for the business, they get to not have personal liability. They do not have any, only the general partners do. And the way that's traditionally done is the general partner is itself a limited liability company or a corporation, and then the limited partners are investors who just put in their money. They're not allowed to participate in them. But the only reason I mention this thing is so that we know it exists. But like all of the other more, let's just say, rare, exotic business entities, unless you know you need one, unless you have already started a different one, have had a number of consultations with an attorney, leave these things alone. Either be an LLC, an SCorp, a SCorp, or a solo. That's all. Now finally we get to the corporation, a C corporation. Now in a C corporation, owners are shareholders, right? They own shares. The full term is shares of stock. As an attorney who writes this term all the time, I often think about what it means to be a share of stock when stock is itself a share of the company. You can break your head thinking about that all day. So it's created by filing the articles of incorporation and adopting the bylaws. This is very important to understand. So you need both items. You need to adopt the bylaws and file the articles of incorporation. And this is probably should have talked about this sooner. When it comes to limited liability companies and corporations, and any of these things that are not just being a solo, there's two ways to create them. You can create them for tax purposes, and you can create them for legal purposes. To be able to file taxes with the IRS on your creation, all you really need to do is file the articles of incorporation with the government, with the state government. You have that one piece of paper, you get your IRS number, you're good to go. But if somebody sues you and you get in trouble, that's absolutely not enough. You need to show your corporate book or your LLC book where you have fully activated the company. For corporations, that means adopting the bylaws, having your first shareholder meeting, electing the board, having a board meeting, meeting minutes. You need all of this records to be legally created for the purpose of defending a lawsuit, for the purpose of avoiding personal liability. You also need to have insurance because it's called being capitalized. So anyway, getting back to the elements, shareholders are not personally liable in a corporation unless they give a personal guarantee, which for most small companies happens a lot. For any big deal, if you're doing like a lease, the leasing entity is going to want you to give a personal guarantee. Engage in torturous conduct. So just because you own a corporation doesn't mean you can punch somebody in the face and say, I did it in the name of my company. You are still going to be sued for battery personally. Receive improper distributions. If you steal from your company, you're going to get sued personally. If you commingle personal assets with the company, constantly drive a company car, eat a company lunch, have the secretary do your dry cleaning, you're going to be subject to what they call an alter ego claim, and you're going to be personally liable. So there are still ways, criminal activity. So it's not an absolute shield, so you got to watch out. One of the things about a C corporation, we talked about double taxation. A C corporation is taxed once when the money comes in, and then when it's dispersed out through dividends. However, even though this entity has the highest tax rate, it is also the easiest entity to build funds in for future purchases, because once you pay the corporate tax, which is relatively small, the money can then sit there and not be taxed and accumulate and grow. So let's talk about the state of a corporation, right? So if you want to form your corporation, probably wondering, Well, you might not be, but a lot of people are wondering, what state do I go to? Where do I file the articles? Because you've probably heard a lot about either Delaware or Nevada, because those seem to be the rumors going around here. Now, if you are in the Bay Area and you're a venture capital company, or you're looking for venture capital funds, you probably may want to consider Delaware. But even there, a lot more companies are now filing in California. Unless you are specifically a software startup looking for massive venture capital funds, you shouldn't even consider anything else that isn't California. The problem is, you've probably heard that maybe laws are more favorable in Nevada or something like that, but there's a couple of issues with this. First of all, if you operate in California, you're bound by California law. You're bound by California employment law. You're bound by all California laws. And it doesn't matter where you're registered. And now you have to register in California as a foreign entity, which adds an extra layer of complexity. And if you get in some kind of legal issues, you're going to need to hire an attorney that specializes in California law and whatever that other state is. And you might have to go to that other state to defend the lawsuit. I mean, I had clients who formed a company in Delaware, as they were heard, because Delaware is much more business friendly, and it is. It's much more business friendly for Delaware businesses. And then when it was time and they got sued in Delaware, they basically had to settle because they live in California and they couldn't afford to maintain a lawsuit in Delaware. Fly to and from Delaware all the time, hire a Delaware attorney. They don't know anybody in Delaware, right? It's important to understand where this whole reputation comes from. Delaware has one of the best business Secretary of States, one of the best business courts in the country historically. And the reason for that is Delaware has the best laws for avoiding shareholder revolts and for basically if you're a company and your board of directors has mismanaged the company, they get the greatest amounts of protections in Delaware. So historically, all of the very large companies whose boards are very concerned about being sued by shareholders have registered. Coca-Cola, whatever multinational or national sized company, they all because they can register in any state equally, they all register in Delaware. As a result, there's a lot more business lawsuits in Delaware, and Delaware has developed a special process for business lawsuits. But unless you are a fully nationalized company with a huge board and not worried about litigation in whatever state, the disadvantage of being so far away outweighs any advantage. Because the courts might deal with lawsuits there easier, you still can't afford it. You can't afford to go to Delaware. And I know some of the people watching this have not heard about filing in Nevada or Arizona or whatever for their favorable, better laws, but a lot of people have heard. All of that stuff is just a bunch of malarkey. It's horrible advice. There's no reason to file in Nevada or whatever other state. That was just a bunch of lies. And anyway, incorporate where you operate. If you operate in California, incorporate it in California. Even if you were like an online business, if you live in California, incorporate in California. So this next slide is called forming incorporation. And here I put a whole list, what you do to form a corporation. Remember, an S corporation is the same thing as a C corporation. It's just that after you're forming your company, you file an extra piece of paper called a subchapter S election with the IRS, and your tax guy will do that for you, or you can do that yourself. It's pretty straightforward. And then you become an S corp. It's just a tax treatment. So forming is the same. So the first thing you do is you buy a corporate binder. Literally, this means you go to Amazon and you type in corporate binder or corporate kit. You're going to find a bunch of these things. They're around $40. It's a binder with a bunch of dividers. Buy it. You can probably build one yourself cheaper, but not easier. This will have all the stuff you need. It'll have some share certificates. It'll have all the basics to get you started. Okay, so you have that. Do not buy the one with a seal. You don't want to seal. It's just, back in the day, corporations used to put their seal on everything when that kind of fraud was a concern. It's not a concern anymore. You don't want to have some kind of a rule that says that every corporate act has to have the seal because you're just going to forget to use the seal. Most companies forget to use the seal, and then literally they have invalidated everything they're doing because they're not using the seal. So don't get a seal, don't use a seal, forget about the seal. So anyway, so you buy the binder without the seal. Next thing you do is you file the Articles of Incorporation with the Secretary of State. I think you should be able to do that online by now. The California Secretary of State website is constantly updating. They've been going online and doing more things online over the last year. So I'm not totally up to date as to what you can and can't do online at this point. For LLCs, I think you can file the formation online. For corporations, I'm not totally certain. But it's the Articles of Incorporation. You put in the name of the company, the address, all the basics, and you just send it in. It's really straightforward. Who do you want to be as the agent for the process of service? You can Google and hire another company for like $50 a year, but I recommend you just do it yourself. There's nothing really, unless you're doing something really secretive where you don't want your name anywhere near the company, just be the agent for the process of service. So after you filed the articles and you bought the corporate binder, you have to figure out who's going to be on your board. I recommend a minimum of 3 people. So the rules are for a corporation with 1 shareholder, minimum 1. Corporation with 2 shareholders, minimum 2. For corporations with 3 shareholders, minimum 3. And then from then on, 3 is the minimum. But here's the thing. You don't want to have 2 people as board of directors. How are they going to make decisions? Everything has to be unanimous. And you also don't want to have 1 person as a board of directors because it looks bad. One of the reasons you're doing all of this is to avoid liability. And you avoid liability by showing that there's a separate entity that isn't just you, the owner. And it's hard to say that when the entire corporation is just you. When you maintain all the offices, when you're the owner, when you're the board, different judges take that differently. Some judges don't care. Some judges do. And so it becomes a little unpredictable. But what's not unpredictable is that if you did have 3 people on the board, you would be totally fine. So find some friends, other business owners, you be on their board, they'll be on your board, have, lunch once a month, have your board meeting, make it easy, but find other people to be on the board and have 3 people on the board, please. You also are going to need officers. Every corporation needs at least a treasurer, a president, a secretary. A treasurer is sometimes called a CFO. President is sometimes called a CEO. I'm sure there's some name for a secretary out there that's fancier, some kind of a C, but maybe COO, I don't know. A secretary is not in charge of taking notes. They're not like a secretary. They're in charge of maintaining all of the corporate documents, keeping them up, things like that. Treasurer and president, self-explanatory. You don't need to have a vice president, but it's nice. So shareholders elect the board in their annual shareholder meeting. The board appoints officers. Once you have all of these things in place, or you know who's it going to be, you have your annual board meeting. You have your initial shareholder meeting, where you do the elections, you appoint the officers, followed by the annual board meeting, and you approve the bylaws. Get a copy of the bylaws somewhere that you can approve. A couple of caveats. Once you become an LLC or a corporation, you always will need an attorney should you have a lawsuit, right? That's one of the costs. If you're a solo, you can represent yourself. But only an attorney can represent corporations and limited liability companies. And it's important that you maintain formalities by having that annual shareholder meeting, keeping your bylaws, and maintain the binder. If you fail to observe the corporate formalities, you will lose your liability protection. I suggest having a board meeting quarterly at least. Just generate some notes that you're having one. It's very easy, and it's more important. It's not important how well you do it. What's important is that you do it. In other words, should you get in trouble in a lawsuit, the court, the other attorney, they're going to want to see your corporate binder. And if you have a corporate binder where there's meeting minutes and resolutions, even if they're written badly and incorrectly, if they're handwritten on a piece of paper, it doesn't matter. What matters is that you have them. If you don't have them, then it's going to be very, very tough road to climb, right? So if you have this stuff, the standard is very low. But if you don't have it, the standard is very, very high. Some of you might be thinking at this point, all right, well, I got these steps. I don't really know how to do them in detail. What do? I don't know. Where do I get a bunch of bylaws? So this is the most valuable piece of information from this whole presentation. Obviously, if you can afford it, go to an attorney such as myself. I'll set you up with all of this. But if you can't afford an attorney, absolutely do not use any of these online services like LegalZoom or Rocketbook or whatever, Rocket Lawyer. All of these services are awful. They're basically, if you look at their ads, they're always telling you how the attorneys don't like us because they put us out of business. That's not true. They're actually generating a great amount of business for attorneys, just litigation attorneys, because lawsuits become more frequent and more complicated because everybody has the wrong documents. They're also longer, more difficult to understand. Don't use those things. What do you use instead? There are actually great cheap solutions. The best one that I know is something called Nolo, and it's Nolo. It's a publication. I don't remember if it's nolo.org or nolo.com. It's a legal book publication. Attorneys use it too, but it's made for non-attorneys, and they have a book of forming a corporation, and they'll have a step-by-step creation of your bylaws. You can't just pay and get it delivered because bylaws don't work that way, and that's why you get all the wrong stuff from Rocket Lawyer, because they don't ask you enough questions, they don't appraise what you get, and you get the wrong set. Here, you'll be able to go along with the book, you'll be able to create your own bylaws. It's going to be pretty easy, and it's going to be the right stuff. So that's what you do. If you're not using an attorney, you go to Nolo. Those books are $40. It's the best in terms of cheap legal services. You're not going to do any better than that. All right, so next, let's talk about the subchapter S election. So you formed your corporation, but you want to be a small business. You decided you want to be a subchapter S. There's a single piece of paper that you have to file with the IRS, right? You're not going to have corporate tax anymore. You're going to be a pass-through entity like an LLC where everybody will pay taxes immediately. A couple of special considerations about subchapter S corporations. They have a maximum of 100 shareholders, and they can only have one class of shares. So when you have a C corporation, you can have somebody who owns 20% of the vote, but gets 30% of the profit, and also is insured where if the company sells, it gets 50% of the sales proceeds. And somebody gets, 80% of the profits, but 0% of the vote. You can have all of these complicated things. In an S corporation, you can only have one class of shares. So everybody owns, so each share provides the same rights. The only difference is you don't have to vote. So there could be voting shares and non-voting shares, but other than that, they have to be the same in terms of profit of sale, everything. The amount of you can't have somebody have double the vote of somebody. You can literally just have non-voting shares and voting shares. But other than that, they have to be identical. It's a pass-through taxation. We covered that. The other thing with subchapter S corporations is the working owners must receive a reasonable salary. You can't just get it all in the dividends. You have to get a reasonable compensation, and that means higher tax. And I think the roof is $120,000 before you can. Anyway, the main thing to be aware of with the S corporation is the shadow income problem. So with an LLC, the money just kind of flows directly. But with an S corporation, the money stays, and then the board decides when to distribute the money. However, you still owe the tax on the profits. So for example, let's say the corporation makes $1 million in profit, and you own 33% of the corporation. However, the board of directors decided not to distribute any money this year. You still owe tax on your third. And that's why the bylaws of subchapter S corporations and the shareholder agreements usually have a special provision that says that at a minimum, the corporation will distribute the amount of money necessary to pay the tax. something to be aware of before you end up in an S corporation. All right, now we cover LLCs. LLCs are, as I said, they're very similar to partnerships. In fact, that's where they come from. It's a partnership with limited liability. You get the limited liability protections of a corporation. You get the flexibility of a partnership. There's not really formalities. But when they say that, even though in the code there are no formalities, even though there are no requirements, you still have to observe the formalities. And what I mean by that is, if you have a small LLC and you have a skillful attorney suing you, they're going to want to know, they're going to want to see proof that you've maintained this LLC separate from your personal assets. And the way they're going to be, the way you're going to assuage them, the way you're going to prove them to be wrong, and the way you're going to say that, no, this is a separate company, this is not my personal assets, is by providing them with an LLC equivalent of a corporate book, an LLC book, and say, hey, the managers, the members have met, made decisions. So even though you're not required by code, the law still puts this requirement on you. You still have to observe formalities. You have to show that you treated this company differently, create an advisory board, whatever it is. That's why a lot of LLC membership agreements that I've seen actually follow a structure very similar to a corporation, where they'll call it a board, they'll elect a board, they'll have officers, even though that's not really in the limited liability code, but it's an easy way to prove that it's a separate entity. It's not a federal entity, right, as we discussed. It's just a state level entity, so the taxation is sort of depends how your CPA chooses it. It can be as a solo, or as a LLC, or as an SCorp, or as a C-corp. It's really up to you. So instead of shareholders in an LLC, you have members, and a membership interest instead of shares. And LLCs are operated by managers or by members. And when you file the articles of organization, you will have a choice. You're going to be either a management-run company or a member-run company. Now, you want to be a management-run company, sort of if you think back to the limited partnership. If you have people who are investors who are not going to be active, they can be members, and the people who are going to be active, they can be managers. If everybody's going to be equal, then everybody should just be members. Managers have enhanced duties. They have fiduciary obligations to the shareholders. They have fiduciary obligations to the members, whereas members don't really have such strong obligations to each other. They're just, everybody's in it together. But a manager is somebody who's like special. They're in it for the members. Profits and losses. This is one of the advantages of a LLC, can be divided in any manner. So the two best limited liability entities for small businesses are S corporations and LLCs. And if you remember, S corporations have only one class of shares except for the voting issue. So everybody gets the same amount of profits regardless of their ownership, right? If you own 10% of an S corporation, you get 10% of the profits. With an LLC, you're actually free to split that up any way you want. Somebody can own 10% of an LLC but get 30% of the profits. There's none of that single class of shares requirement. You can make any agreement you want amongst the members. Economic interests are assignable, but voting and management interests are not. And what I mean by that is, if you think back to what I was talking about closed corporations, why LLCs are good for families, it's because your drunk brother can go sell his financial interests in your LLC, and then the profits that are coming out of the LLC can go to whoever he sold it to, but he can't sell the vote. He can't sell the control. So you can't be forced to suddenly share the ownership and the management with somebody else. And he maintains that ownership, but it's diminished to some extent because he doesn't get any money out of it. So the people in LLC are kind of stuck together, and that's sometimes very valuable, something to be aware of. This presentation is originally intended to be for about 2.5 hours, but with also feedback. So I've trimmed it a bit. There's going to be additional slides that I don't know if they'll cut off or maintain, but we're pretty much done with our basic coverage. But let's talk a little bit about California tax, because there's a lot of sort of weird stuff online. I just want to get everybody on the same page. Sole proprietorships and partnerships in California have no special tax. I mean, you're going to pay your tax the way like a person who makes money pays tax, but the entity itself doesn't get taxed. C corporations have a minimum tax of $800 a year. That's the minimum. And then they get taxed 8.84% on profit. It's high. C corporations have the greatest tax, but the greatest benefits, and that's why they're great for large companies. S corporations have a minimum $800, and they get taxed 1.5% on profit. Now, LLCs are very different because they also have a $800 minimum fee, and then they get taxed based not on profit, but on gross receipts, that is on revenue. And in the slide, you're going to see a chart which basically tells you for how much money in revenue, how much tax you pay, but it's from $900 to $12,000. So let's take a look at an example. Let's say there's a company that has gross receipts in the amount of $400,000 and profits in the amount of $1,000. So $400,000 in revenue, $1,000 in profits. Important to understand that the $400,000 in revenue, your salary, you already got your salary out of that. So it's $1,000 in pure profits. You already got your money. So as an S corporation, you're going to pay a minimum of $800 because your 1.5% is way less than $800. That's the minimum. As an LLC, you'll see the calculation in the slide that between $250,000 and $500,000 in revenue means you're paying $1,700. That's a net difference of $900. Let's take a look at another example. A company has gross receipts in the amount of $2 million and profits in the amount of $100,000. As an S corporation, you're paying 1.5% of the profits, $1,500. As an LLC, with such huge revenue, you're going to be paying $6,800. So the general rule is that a business with high revenue and low profit margins and businesses operating with generating losses will benefit from being an S corporation. Right? But businesses with low revenue and high profits, they'll benefit from being an LLC. I hope you learned a little bit about the difference between the various entities and the importance of maintaining formalities, because if you want protection from liability, you have to maintain the formality. Filing tax is easy, but we're all worried about the worst case scenario, about the lawsuits. In those situations, we do have to maintain the formalities to show to the judge and opposing counsel this is indeed a real company. If you're going to be forming a corporation, please, please, please get 3 people on your board. If you're going to be forming an LLC, please, please form some kind of a meeting of something like a board that regularly meets and maintains a binder. Now, generally speaking, a sole proprietorship is the easiest to form. LLC is the next easiest. S corporation is the easiest after that. And C corporation is the hardest. And the general path for most businesses is you start as a solo, then you move on to either being an LLC or an SCorp, either one, and then eventually you move on to being a C Corp, because you're going to be any kind of a business that has a lot of employees. C Corps are usually where it's at if you want to provide them any benefits. If you have any questions, my contact information is in the presentation. Feel free to shoot me an email or give me a call. But I think that's pretty much all I got for now.